Hello, everyone, and welcome to our show, Inside Immigration. I hope everyone is doing well and that you had a wonderful week. We have a great show for you this week. We're going to break down and discuss some of the most pressing immigration topics for this week and answer your questions. I have great topics today. We're going to discuss the filing fee increases, which is a huge breaking news for us here in immigration world. And I'm also going to talk a little bit about marriage-based immigration cases because you guys have sent us a lot of questions about that. So I am going to talk about immigration based on marriage. I'm immigration attorney Yael. We're located in Orange County, California, and we are here representing clients from all over the world. If you're new to our channel, this is the first time you're with us, thank you so much for joining. Please follow us, like us on Facebook, follow us, subscribe to our channel on YouTube so that you can receive more updates about immigration and receive more notification about content that we are providing. Okay, so welcome everybody. Today we have, like I said, some really great topics. Hello everyone for joining. The first topic I want to discuss today is something that's very urgent and very relevant for a lot of people that are on the fence or on the verge of filing their immigration case. And this is the increase in the filing fees that is expected. So we've been waiting for this, anticipating this. And finally, last week, immigration has announced that they're going to increase the filing fees for a lot of the different applications that are required for an immigration case. Now, why is this significant? It's significant because it's a significant increase for a majority of the application, and it just makes the whole case more expensive. The increase is going to start April 1st of 2024, and it's going to affect mainly immigration cases filed based on marriage or family-based petitions. Okay, so the overall cost of a family-based immigration petition, a marriage-based case, for example, would go from right now being about roughly $1,800 for filing fee. It's going to increase up to $3,000 after April 1st, 2024. So the petition, the I-130 petition, the family-based petition is going to go up. The adjustment of status application is going to go up. And a new thing that is starting April 1st, 2024 is that there's going to be a fee for the work permit and travel document. Okay, what we call interim benefits. So when you file for an immigration case, you can also request a work permit and a travel document while you're waiting for your case. And that used to be free. That used to be part of the application fee. Well, not anymore. Starting April 1st, 2024, this is no longer included, and there is a fee for this. So if you want to also have a work permit and a travel document while you're waiting for your case, that will cost you. There will be a charge for that. Okay, so filing fees for a marriage-based, family-based case is almost double. Okay, and a lot of people have been asking, during the week since this has been announced, can we still file our case? Do we even have time to file our case before April 1st? So yes, it is possible, but it's imperative to start your case as soon as possible, right? Because April 1st is just around the corner. So if you are thinking of filing an immigration case, you're on the fence, you're on the verge of filing, and you're waiting, do not wait anymore. Try to get your case filed as soon as possible. Really, there's no reason to pay almost double for your case. Okay, but it's not just the family-based immigration, it's removal of conditions, it's naturalization, appealing a case that's denied, extending your status, changing your status, everything will be affected. Okay, so that's just one of the reasons for you to take action and start your immigration case. Now, another reason to start your immigration case is, and if you've been following me, you know that I have been encouraging everyone to take action on their case because right now it's a very good time to file, and this is going to change. This could change in the near future in this upcoming year. Okay, we know that this is an election year. So this year in November, we're going to have an election. We might have a new administration. And a new administration means new policies, new procedures, new laws, and everything that's new could be new to the worse. Okay, it could change. Okay, things that are now available could not maybe not be available anymore for immigration. Okay, so take action on your case. I could not emphasize this more. Okay. So if you are joining us on this show today and you have some questions, feel free to write your questions in the comments, and I will happy to answer them as we go. Okay. Just a reminder that everything that we say in this show is general information. It's not considered legal advice, but if you do want legal advice, that would be more appropriate for a one-on-one consultation. Okay. Wonderful. So we discussed the filing fees. We discussed that they are going up April 1st, 2024. So very shortly, less than a couple of months. And now I want to dive into a topic that is very common to most of our questions that we receive. So we receive a lot of questions during the week, and a lot of them have to do with marriage-based petitions, marriage-based green cards. And we love marriage-based green cards, and there is a lot that go into them. So I thought today to talk a little bit about the basics of these petitions and to really dive into what a marriage-based case looks like and what's important for these kind of cases. And then I'm happy to answer any questions as they come. Okay, guys? Perfect. So what is a marriage-based case in immigration world? Okay, so if you're a US citizen and you have a foreign born family member, okay, maybe you're a US citizen or maybe you're even a lawful permanent resident, you're a green card holder, and you have a family member that's a foreign born national, so born in a different country, and you want that foreign national to come to be in the United States to live with you, you can petition them. Okay, you can file a case for them. So if this is in the marriage-based world, it could either be your fiance, right? So someone that you're going to marry, or either it could be your spouse, someone that you're already married to, right? So as a U.S. citizen or a lawful permanent resident, you can sponsor your partner for the green card to become a resident in the United States. And what does this petition or sponsorship look like? There's two main parts. It starts with a petition. It always starts with a petition by the US citizen or green card holder petitioner. And in this petition, what immigration basically wants to see is that you are in a bona fide, what's called a bona fide relationship. So you are in a really true relationship. You love each other and you intend to live together as a married couple. Okay, you're not doing this process just so that the foreign national or the beneficiary will get a green card. Okay, you're doing this because you are in a genuine relationship. Okay, so the petition part is going to first confirm that it's basically two things or three things. The petition wants to see that you, as the petitioner, can petition, right? And that the relationship is legitimate, is bona fide, is real. Okay, so in the petition, that's where you submit all the proof of your relationship. That's where you submit pictures. That's where you submit joint documents, right? If you guys are living together, then proof that you're living together. If you have a joint bank account, if you have children together, if you have insurance policies together in both your names, right? Sometimes when a couple is a new couple and they're not living together, or maybe you guys are living in different countries, then it gets a little bit more difficult to provide joint documents, but it's still possible, right? Pictures are always available, affidavits from friends and family, a declaration, a statement by you attesting to the relationship. and similar things. Okay, so the first part of your marriage case is going to be this petition. Now, once your petition is approved, the second part is going to be the beneficiary or the applicant's request to become a resident. Okay. Now, this request differs, it changes depending on where the applicant is or the beneficiary is. So, if the beneficiary is in the United States, right, they're here and they're eligible for this, they would be applying for adjustment of status, right? They might be applying to adjust their status to become a resident. If they're not eligible to adjust their status or they live in a different country, then they would be applying for something called an immigrant visa, okay, in their country. And this second part really now focuses on the applicant and the beneficiary. And at this point, immigration has already determined that you have a bona fide relationship, a real relationship. And now immigration is looking at the applicant to make sure that the applicant is eligible or admissible, what we call admissible to the United States. So immigration looks at things like criminal record, previous immigration violations, any fraud or misrepresentation made to the government. They look into public charge, right? The ability of the applicant to provide for themselves in the future, okay, in the United States. They even look into medical reasons, medical considerations. So part of the process is that the applicant will have to go through a medical examination, okay, to show that they are fully vaccinated and that they're generally healthy. Okay, so you can see that the marriage base has two parts. First, proving the relationship through a petition, and second, proving that the applicant is eligible for this residency, for the green card, that there's no reason that the applicant would be ineligible. So that's mainly the process in general, the process of the green card based on a relationship, based on marriage, right? And a lot of people ask me, one of the most frequently common questions about marriage-based immigration is how quickly after being married can I apply for a marriage-based green card? The good news is that there's no time restriction or time limitation, right? So generally, you can apply pretty quickly after you get married. However, there's some considerations here, so that's a generalization. Sometimes we do recommend to wait a little bit before applying for the green card based on marriage, but in general, the law does not require any kind of waiting period between getting married and applying for the green card. Okay. Let's jump into some of the other questions that we get, some common questions that we get around marriage based or immigrating to the United States based on marriage or based on a relationship. For example, one of the questions that we received this week that's super relevant to this topic is, can I petition my wife for a green card if we're currently not living together? I'm worried that might look bad for us. Okay. Now, every marriage case is determined by their own circumstance, by the facts of the specific situation, right? But if you are both in the same country and you're not living together, okay, that could be a red flag in your case. Okay. If you're living in the same country, in the same, geographical area, and you're not living together, that's something that definitely can come up in your immigration process. And on the other end, if you are in different countries and you're not living together, and the reason that you're not living together is because the foreign national does not have a visa to come to the US and they're applying to come to be able to live with their spouse, that's something different. Right? This situation is more if you're living in the same country, would that affect your case? So it could be a red flag. And really the reason is that if you're living in the same geographical area, let's say for for in the same state, and you're not living together, then why are you not living together? Right? What's the reason? Because typically a married couple living in the same area will live together, right? That's the typical situation. So there could be circumstances where this is not true, but doesn't mean that your marriage isn't real, doesn't mean that you're not in a valid relationship. So one common scenario is that if one of the couple is in school, still is a student, and they're still going to school, so they're in a different state right now, or they're in a different country because they're going to school. Okay. Another example is that one of the couple is in the military, so they travel a lot, or their work requires them to travel a lot, and to be away from home. Okay. As long as it's a temporary situation, as long as there is an explanation to the fact that that the couple is not living together, um, usually it's okay. Okay. It's all about, can you provide an explanation? Can you provide evidence to show that despite the fact that you're living in the same area, you're not living together, you still are a valid couple, a still valid relationship, then you can be just fine. Okay. If you are joining us now, welcome, welcome. We're talking about immigration topics. We're talking today about marriage-based green cards. If you're here, you just joined us, welcome. Feel free to write questions if you have. I'm happy to answer them as we go. I'm answering some questions that came in this week that pertain to marriage-based green cards. Okay. Wonderful. Another question that we have here is, how quickly can I apply for a fiance visa? My girlfriend is from Mexico and we met last month. Okay, that's a question that we just got in today. Well, that goes to the same kind of thing that we talked about earlier about how quickly can we file for a green card based on marriage. So with the fiance visa, there's no limitation. You just have to meet the requirements. And the requirements for the fiance visa is that you must show that you're both free to marry, that you met at least one time in the last 2 years, and that you have an intent to get married in the United States. Okay. So if you can show that, then you are eligible to file for the fiance visa. Now, if you've just met last month, you might not have a lot of proof to show that your relationship is bona fide, that your relationship is real, okay? Because you don't have a lot of time together. But that doesn't mean that you cannot file for your case. Usually in those cases, my recommendation is to file and then to continue to accumulate more evidence and to show proof of your ongoing relationship. Okay, because you might receive a request for evidence, you might receive a request from immigration to provide more documents in your case, and you want to be able to supplement the record. Okay, so really document your relationship as much as possible. Go visit each other as much as possible and keep evidence of your meetings together. Okay, pictures, flight tickets, if you guys go to a hotel together, if you guys visit different attractions, if you do things together, record everything. Okay, keep everything because everything is evidence for your relationship. Okay, perfect. Let's see what other questions we got here. Okay, there's a question here. I want to petition my wife for a green card, but there's a 15-year gap between us. Will it look suspicious? Okay, guys. So that's also a common question. People are nervous about their situation. They don't know if their relationship would qualify, if they're going to be asked questions about this age gap, when they have an interview for their immigration case. So certain things, fact patterns could raise questions and could be considered red flags. And I say that with quotation because, you know, really there's no rule to what a relationship looks like, right? There's no right or wrong relationship. Everyone has their own relationship, right? So there's no rules in this, but there are certain scenarios where that could be considered red flags. Okay, so a very big age difference can be considered a red flag for an immigration adjudicator, for an immigration officer. Okay. Other things that could be considered a red flag is if there's cultural differences between the couple. So from a different cultural background, different countries of origin, language barriers. So if the couple, if you guys don't speak the same language, right, the petitioner and the beneficiary cannot speak the same language, that could be a red flag. Okay. Previous petitions, if someone has petitioned someone in the past and now is petitioning someone right away, someone else, that could be a red flag. So what do you do if you have a big age gap? That doesn't mean that your green card based on marriage will not be approved, not at all. That just means that your case is going to be scrutinized a little bit more. Okay, that just means that you might be asked more questions. Okay, if you're in the United States, that means your interview might be a little harder, a little bit more trickier. And when I say hard interview, I mean you might be asked more questions, you might be separated, right, at your interview. So that's okay. We have helped hundreds of clients in these situations, and it does not mean that your case might not be approved. It just means that you have maybe a higher burden. Okay, you might have to show more evidence, more proof of your relationship. Okay. Perfect. But I don't want anyone to be discouraged. I don't want people to be discouraged. If you're in a real relationship, but you have a big age difference or you're not living together, that does not mean that your marriage based case will not be approved. Not at all. It's all about how credible you are, and it's about how you can show the bona fides or the truth of your relationship. Okay. Wonderful. Let me pick a few more questions here. Okay. Can I petition my husband if I'm currently not employed? Another really common question. So there is a requirement of the petitioner to file what's called an affidavit of support. Okay, so there's a requirement to file an affidavit of support to show that the petitioner can financially sponsor the applicant, the beneficiary, in their case. Okay, so you have to show that you make a minimum income. Okay. Now, what do you do if you're not employed? So you do not have income to show. Well, first, rest assured that this is very common. A lot of people are either in school or they're in between jobs. So it's common. What you can do is first, if you have any assets, meaning you have any real estate property, you have any savings in the bank, you might be able to use those assets to supplement your income. If you don't have assets, then you would be able to use what's called a joint sponsor or co-sponsor. Anyone that's a lawful permanent resident or a US citizen will be able to help you by being a co-sponsor in your case. Okay, being a sponsor with you. Okay, so the fact that you're unemployed or you don't have sufficient income does not necessarily mean that you cannot petition. It just means that you might need either to use assets or to use a co-sponsor. Okay, wonderful. Well, I think we covered a lot of questions today. We discussed the filing fee increase, that immigration is going to increase the filing fee starting April 1st, 2024. So it's very important, guys, if you are on the fence, if you're considering filing for your immigration case, please go and take action on your case, because it would be really a shame to have to pay almost double on some of the cases. Okay, if you have a case, if you are on the verge of filing, don't wait. Okay, and then we talked about immigration cases based on marriage. Okay, and we talked about the elements of these cases, and we talked about some common questions. Samuel, I see that you're asking a question. Let me see if I can answer it real quick. I submitted my I-130 for my spouse in Bogota in January. I received a receipt notice telling me a pending decision is in 2 months. Can that be accurate? You submitted the I-130 in Bogota? Do you mean that you submitted the I-130 to USCIS? Samuel, I think you have a pending case. Do you have a pending case with an immigrant visa? I would need some more information. So give me some more information so I can answer properly. Okay, so while we're waiting for Samuel to give me some more information to USCIS, yeah. So you submitted an I-130 in January, 2 months of a processing time. If you filed this January, sounds pretty quick, but could be possible. Could be possible. She's from Colombia. Okay, great. Keep following the case and hopefully you'll get a quick decision on that. Okay, perfect. Okay. Well, it was such a pleasure to be here today. If you have any questions, always feel free to reach out to us and join our show Inside Immigration every Thursday, 5:30 Pacific, to learn more about immigration and to get your immigration questions answered. I'm immigration attorney Yael Brudner, and it was a pleasure being here. And until next week, please be safe and healthy. Okay.